Thank you, and thank you for inviting me.
Sure, it's great to hear from you. And did you see Katie Cool-Lady's video about your letter?
I did, and I'm going to have to confess to being a flawed human being because I just loved it.
Why would that
Maybe
make you
not
flawed?
accurate, but it was fun to hear.
Yeah. What did she say, that you stuck the landing, or she was giving all these superlatives.
I liked it when she said she thought she was going to have to cigarette and she didn't smoke.
That was funny
It
too.
was.
Yeah. Yeah, I wonder, have other people ever made a video about you, praising you to the heavens like that?
Not a video, but I had a reporter from USA Today um, several years ago now. I chaired the Committee on Infractions for the NCAA, and we were doing a case in California, and he wrote this lovely little piece, and he said the person that the coaches have to be afraid of and worry about more than anything else in this case will be sitting at the head table, and she's the shortest person in the room, but she's going to be the scariest. And I like that one too.
Yeah. You sort of look like Ruth Bader Ginsburg. Has
Oh,
anyone said that?
heavier. But
No,
thank you.
yeah. So how did you get into going to law? I saw that you started teaching back in 1974,
Yeah,
which, I mean, there must have been no women professors then.
that's pretty much true. When I was a kid, I always thought I wanted to be either a sports writer or a lawyer. And my mother at the time said, no, women don't go into either of those careers. And so and I was very influenced by her. And of course, neither of my parents went to college. I'm the child of immigrants, and I went away to college when I was 16. So, and there was nobody to talk to about what can you do. I mean, it's so different today. It's wonderful today. So I did worked for a couple of years and got a master's, and then decided, you know what, I really want to go to law school. So I'm going to do this. So actually, when I told my mother, she didn't say that's wonderful, that's great. I got silence from her, although she was really a great revisionist historian, because 10 years later, she bragged all over the place and claimed never to have discouraged me. But anyway, my first day of law school, because my only picture of law was Perry Mason, this stuff. My first day of law school, professor said, "What is a tort?" in a Southern drawl, and he was so gentlemanly. And then nobody answered. And then he said, "Doesn't anybody out there get a good liberal arts education anymore?" And I thought, this is what I want to do with my life. So when I graduated from law school, I was lucky enough to go right into teaching. I thought I'd do a clerkship or something else. Maybe in retrospect, I should have done something else first, but I got a few offers for positions, and I went to Nebraska. I had somebody on our faculty who said, find some place when you start where you feel comfortable, because starting teaching is very lonely. And you're going to need a lot of support, and you want to be somewhere where you really like the faculty. And I did, although I had no idea where Nebraska was on the map. I mean, I was a typical East Coast person. I had to look at a map to see where it was. And then I was flabbergasted. I still can remember that Chicago came after Indiana. I think that's the way it goes. I'm not even sure now. I mean, I just couldn't, it was amazing to me. So I went out there thinking maybe I'd only stay a few years and then move back to the East Coast. And I do like the East Coast, but it really was such a great faculty. And so I had a chair in constitutional law, so I taught around the constitutional law classes, and I taught criminal procedure and criminal law. And at one point, I decided I really needed some practice experience, see what it was like out there. So I came back and worked in Essex County, New Jersey, which is the county that covers Newark. And I worked for a year and a half in a prosecutor's office and got in some juvenile trials. I couldn't wait to get out of juvenile.
Oh,
And 7 felony trials. And I did some what they call in-service training, which means for the detectives and the investigators. on criminal law and procedure. But it was interesting. I thought when I looked around to do that they would just grab me, because here I was, I'd been teaching law and I'd written criminal law articles, and I thought I was a real get. And what they all thought was they were going to get somebody in an ivory tower who wouldn't be able to relate to a jury or even the other prosecutors in the building, and certainly not with the police. And it was very nice at the end, because at the end of the year and a half, the prosecutor invited me in and gave me an offer of a full-time position. So I thought, well, I have convinced them that I can talk in a way that the rest of the world understands. So that's what I did. And then a few years after that, sports, not so much a lot of the East Coast schools, but in the Midwest and the South, particularly, sports are a really big, important component of universities. And I thought, if there are going to be athletes on campus and athletics on campus, there really has to be close supervision by somebody from the faculty, and somebody's going to really pay attention. And there's an NCAA required position at every university. You have to have somebody, tenured faculty status, who has some oversight. And so I got that position. And that meant I went to, sports meetings. That's how I ended up on the infractions committee. So that's more than a nutshell. I'm sorry, but that's.
Oh no. So did you grow up in New Jersey?
Yeah.
And were your parents from Italy?
Italy, that's right. They both came from the small little poor town in southern Italy. They emigrated at different times. That part of Italy all emigrated to the same part of New Jersey. My father claimed that he knew my mother was 5.5. My father was 16. My father claimed that he knew her in Italy when he was 6 and she was 5. She claimed she had no memory of him whatsoever. But yeah.
Yeah. So what did your parents do?
My father was a baker. That was everybody learned a trade. One of his brothers was a carpenter, and he was the baker. And my mother finished her career as the principal clerk of a welfare office, the Essex County Welfare Office. So she was in charge of all the clerks there.
Yeah.
Clerks and secretaries, staff, not the welfare workers, the professionals.
Okay. So we had talked about how you empathized or sympathized with Dan Markel because he was also a young law professor. Can you tell us a little bit about, what you know about how people get their legal jobs?
Yeah, it's not like you don't go to school of education, as you know, or anything else. You come out of law school, you have to have had a really great academic career in law school. And then typically, particularly these days, those who want to go into law teaching generally get a federal clerkship. Sometimes they work 3 or 4 or 5 years at a big national law firm. These days, they all have published something before they get in the market for teaching. When he went into the market, that would have been true, but less so. And the way the hiring goes is law schools are run by faculty. It used to be universities generally were run by faculty. That's probably no longer the case, but law schools definitely are. And the tenured faculty makes the hiring decision. The tenured faculty makes the tenure decision. The tenured faculty decides about full professors. The tenured faculty and the tenure track faculty make governing decisions about how the law school is going to be run. And what you do is, it used to be you did it by context. It was kind of the old boy network. By the time Dan would have entered and when I entered, the Association of American Law Schools, which is the association of all U.S. law schools, set up what they called a hiring convention, what people who did it called a meat market. And you would send a edited resume to the association, and they compiled all those resumes in a register, and then the register was sent out to all the law schools. It was not done that you would make a direct contact at a law school and say, I'm interested in teaching there, unless you knew somebody on the faculty. So the register was kind of the old boy for all of us who didn't have another connection. And then what would happen is the schools would get in touch with you and set up interviews. For Dan, having had a really illustrious career at Harvard and then having the time at, was he at Cambridge or Oxford? Can't remember now, but the
Cambridge, I think.
yeah, the
Sure.
extra time there, and having worked for a big law firm, a national law firm, he would have had people at Harvard who could have made calls for him the way it used to be done. But I'm sure he was also still in the register.
Yeah, did you hear the story about how Dan had 17 interviews at the meat market, but then he struck out
Yeah,
first with everybody.
yeah.
So he
I
had to
had
go
about that
again.
many too. Well, you know, it's only a half hour. You only have 30 minutes to make an impression. And, you know, faculty, law, you know this, you went to law school, law faculties can be pretty peculiar. And one thing can trigger something. It doesn't take much. And I don't know, you know, for him, what didn't work. I mean, I don't know anybody who would have interviewed him at the time, but I do know what happens sometimes with people who don't make it the first time around. Um, and I'm sure it had nothing to do with his paper record, couldn't have had a thing to do with the paper record. So it was the impression in a 15 or 20 or 25-minute interview. Um, and now I think subsequent to when Dan would have been in law school, now the AALS, the association, holds sessions for people going into the meat market before the interviews, talking to them about how you handle the interview process and what you do and what you shouldn't do. Some people are very outgoing. I had a colleague who was extraordinarily outgoing and a terrific teacher, but in that sort of interview context, he became very quiet and unable to sort of move a conversation. That was not he, but that's what he did in an interview context. And so, you know, that would be a killer for him because, you know, when you're thinking about somebody who's going to teach people who are college graduates who have had careers of their own, you know, you're measuring, is this person going to be able to stand up in front of a classroom and command the room? And so you make the assumption, in my colleague's case, it was absolutely wrong, which is if you can't manage in an interview with 6 people, how are you going to manage in a class with 80 or 100? So I don't know what was the trigger with Dan, but I'm sure it was not his record.
Yeah, well, he wound up at Florida State. Are you familiar with the staff or people at that law school?
Not at that time. I knew someone who was there right before Dan was hired. I went and looked yesterday, but they didn't overlap. He would have been retired, and I couldn't find out whether he had taught the next couple of years after that. So didn't know anybody at least directly at Florida State. I'm sure I interacted with people from Florida State and Miami, for that matter, at professional meetings, but not in a way that I can say I knew them.
Yeah, and you did say you have a contact at University of Miami
Yeah,
who knew
right.
Dan. Yeah, would you like to share your story?
Yeah, and of course, this is from the person I know who was there at the time. Um, what happens in law teaching is you can move to another law school. They call them visits, and some of them are what they call look-see visits, which means you go with the idea that if the faculty likes you, they may make you an offer to come permanently to their school. And that's what his was. And what happens then is you have maybe 7 or 8 months to make an impression with that faculty because the offer has to come by March, the latest April, because if you're coming from another law school, they have to fill your position and they're already covering it for the year that you're on a visit, but they need to find ways to cover it. So in the law school community, you don't wait until the last minute to make a hire, because that's really a disservice to the school that the person is leaving from. Every hiring committee, every law school, every faculty looks for the best academic record they can find. There is no question about it. And everyone, like in any walk of life, any business, any job, looks for somebody who's going to be compatible, a good colleague. So you're looking for both of those things. Most law schools, in my experience, rate the record higher. And if you happen to be an odd duck or somebody they think, gee, I'm not so sure I'd want to go for a drink or anything, that doesn't matter as much as what else you're going to do. Some law schools, and Miami was among them, rate the collegial factor higher. And there's nothing wrong with it, because they're not going to give way on the credential side. They just say we want both. And if you only have 6 or 7 months to make an impression, and people are teaching, and you've got, Thanksgiving break and Christmas break and all this, it's not a long time. And reading between the lines of everybody who talked about Dan, he was, Socratic method, one of the, what we would call the hard A's in a classroom, pushes you, makes you defend your position and see to the end result. And he did that in the classroom. Many law professors are like that. For anybody who saw the paper chase, that would be Professor, what was he? Kingsfield, that sort of professor. And that used to be the only model. Things have ameliorated over the last few years. That must be the model I like. That's the model I am. But that personality also often translates into interpersonal relations. And usually, we enjoy it. It's a give and take. It's fun. There's some people who are not as enamored of that. They want something softer. And I think one of the things that happened at Miami, there probably was a small number who felt that he wouldn't be a fit because he wasn't as congenial in the way that they defined congenial as others on the faculty. That would not have ended with him not getting an offer, though, because you never get a perfect, it's almost impossible that you get 100% of people voting to vote, particularly law professors. But Wendy was doing one of the clinics there, and the clinicians were very unhappy with her performance in the clinic. And they went to the hiring meeting saying they really didn't think she knew enough. They didn't think she worked hard enough. And I don't know how many clinicians there were, but there were a number of them. And their worry was that if Dan was hired, she would continue in the clinic, and they didn't really want her. And so when you took that number plus the number you're always going to get, you're getting to a larger number. And then what happens on faculties is, you're 30, 40 people. And you say, gee, if my colleagues are really unhappy, there are lots of people who want to be law professors. Let's just wait and look again. And that's what happened. But, if he'd been there on his own, I think he would have had that permanent offer.
Well, what do you think about this whole thing of Wendy getting jobs at the law school because of Dan? I mean, she had just graduated from law school, so how good of a teacher could you be if you have no work experience?
Yeah, or doing practice. She was in the clinic, which is, I would say among the worst places to put somebody in who has no experience. I mean, the classroom is bad enough, but you're dealing with practical issues and you're supervising students who know less, and you've got ethical responsibilities. It is obviously not an ideal way to do it, but it is something that happens, and I'm sure it happens outside law schools also. If you really want one person, and you're not going to get that person unless you hire both. I saw some things, and I don't remember where I saw it, and I only have this from reading statements of others that said I don't know whether it was St. Louis or Missouri, one of the schools in the Midwest wanted him to visit, and he wanted it a condition that she would be able to teach, and they didn't want to do that. So they said no, and then he got back in touch and said, well, it doesn't have to be a condition, and they had moved on. So it's tricky to do it because You want one person, you're not so sure about the other. You're going to maybe wed to both. And of course, it's not a good way to do it, but it's the real world.
Yeah. Well, I mean, I never got such an offer because, I was 1 year out of law school when I had to move due to my ex's position. So,
Yeah.
well,
And you know how hard it is on the other. I mean, I will
Yeah.
say, for two career couples, it's very hard if one is going to move to advance a career and there isn't a way to try to accommodate the career interests of the other. And none have to do with, so you were young in your career makes it a little harder. But it doesn't mean that the other spouse isn't, fully qualified to do many, many things. It's how many jobs are there, in a
Yeah.
particular location that you can accommodate both. Some universities these days within the university make an effort in a dual career, not two in the law college, but in a dual career to find a faculty lecture position somewhere else in the university. Now, notice what that does. And you're in another department and you say, so you want me to hire somebody because the law school wants someone and we don't
Yeah.
know this person.
No.
It's not,
Yeah.
it's always hard. It's always hard.
Yeah, definitely. I mean, so that's why I was drawn to the case because I identified with Wendy.
Right.
At the beginning, I didn't think Wendy had anything to do with the murder. This was years ago. But, obviously my opinion has changed. But, I knew the feeling of just being thrown into some new sort of
Right.
podunk type of town because of your spouse's job. And it's so hard for law professors to get other jobs in a more, what do you call it, like a high in demand type of city.
Yeah.
Everybody wants to go to, Boston, DC, California.
Right.
Yeah. Yeah. So Janet wants to know, can you talk about obtaining tenure status? Is it the same school to school?
Yeah, generally, there are differences at the edges, but generally it's the same thing. You come in as an assistant professor, you have 3 or 4 or 5 years in which students will be evaluating your performance in the classroom, faculty will be evaluating your performance in the classroom, and you're expected to do some substantial scholarship. But in many schools, it's 2 completed articles. Other schools don't have a numerical number. And then the tenured faculty votes whether to extend an offer to that individual. That individual these days puts together a tenure file showing everything he or she has done. But most schools, maybe a large majority of schools, teaching is important. And if you're really a bad teacher, you may not get an offer. But if you don't have a scholarship record, that's going to kill you on a tenure vote. They expect you to be productive in ways that bring value to the law school and actually value to the students. That publish or perish. I found even in classes that I taught many times that when I wrote an article about it, I found so many things that I didn't realize were involved because you just don't have time to go that deep um, if you're if you're not writing an article, if you're just teaching. So that Janet, that's the way it generally is. It's a 6 or 7 year process. Sometimes you get credit because you've had a clerkship or you've been many years at a law firm and you may come in with a couple of years credit before you're evaluated, before the tenure decision comes.
Okay, thanks. So did you work at the same place your whole career, or did you move to different
Yeah,
schools?
yes, as a kind of a permanent anchor, but I visited at North Carolina, Chapel Hill, and at Oregon, Eugene, University of Arizona, Seton Hall, Rutgers, Cardozo, and I really enjoyed those because I got to see other schools and you know, how other faculties work. And by and large, we're all the same. But, you know, there would be little things at the edge. So I did that. I also was half-time for about 2 years because I was the project director of a Uniform Law Commissioners project. It was model sentencing and corrections. And so I had to go half-time to handle that project. I also took a year and a half and came back to Essex County to prosecute. So I did, and that's one of the real joys of teaching. And teaching is a joy. I don't want to minimize that at all. But it also gives you freedom to try other things and have the opportunity to do other things. And so I've been a lot of fun. In fact, I had a visiting offer from University of Florida that I wasn't able to manage. I had an offer to go into, and there's so many things I regret not doing. The Judge Advocate Corps at one point. There was another time. It was the Civil Division of Justice. They always have a professor in residence. I hadn't applied, but they had somebody couldn't do it, and a close friend of mine had done it. He had given them my name, and I couldn't do that one. So teaching gives you a lot of opportunity, but you only have so many hours in a day and so many days in a week, and on and on and on.
Yeah, that's right. So tell us about, how did you even hear about Dan Markel?
It was really the last couple of, the end of COVID, when everything was on Zoom, when you were teaching. And so I'm looking around for things to do. And I came across, I don't even remember what it was. And I had heard sort of vaguely at the time that a law professor had been killed, but I didn't follow it then. So I then started following it some. And frankly, what really pulled me to it was Wendy. Because, I don't want to minimize any murders are all terrible. But her way of dealing, I thought, was so terrible. It's not just, being involved in a murder, which I think she was involved in a murder, but trying to wipe out somebody, changing their names, not letting their grandparents or their family seeing them, trying to erase them from their lives. And I thought on my mother and how she would have felt if she couldn't see her grandchildren. That seemed to me to be so evil that it just drew me in entirely.
Long ago, did you hear about the case?
I beg your pardon? I didn't hear you.
How long ago was it that you
Well,
heard about
directly
this?
when I started paying attention was the end of COVID. So what would that be? 2 years ago, 2.5 years ago, somewhere in there. So then I watched, the trial. There had been 2 trials that were on, you could find on video, although it was a little tough. They didn't you just couldn't do it sequentially. You had to keep coming out and going in. That's how interested I was. I came out and went in to see it all. So I got caught up. And then I watched Charlie's trial live last fall.
So how would you critique the attorneys, since you were a prosecutor before?
Yeah, I think Georgia and Sarah do a really good job. I think what they maybe do best, you don't see when they're at trial, but it's the putting together the case and looking at what evidence there is and trying to figure out what we need, and then how are we going to get it in, and what kind of demonstrative exhibits should we use. All of that is an enormous project to do, to get it so it flows, and then to make it flow in a way that's comprehensible and easy to follow for a jury. And I think they did an extraordinary job with that. And once that's done, I think what they did at trial was very good. But I think the extraordinary part of it was how well they were able to conceive and put it together. And I'm telling you, first trial. Now, by the time you get to the third time around, they've got some better idea of how to do it, and they've got a lot of it done. But that's an extraordinary undertaking. I don't know that I'm certain that many prosecutors wouldn't be able to do it, or wouldn't take the time to do it right.
Yeah,
Now, I thought you were going to ask me about Dan.
Yes. What do you think about Dan Nashone?
I think technically he's very good. I think he knows the law. In Charlie's trial, I think he was very good at asking the right questions and getting the right evidence in and all of that. But there's more to being a trial lawyer than that, and I think his feel or his instincts are just off. And I can think of a couple of examples in the closing in Charlie's trial when he told the jury, when you go into the jury room and you're deliberating, you look at something, ask yourself, what would Rashbaum think? Now that to me is such an off thing to say to a jury. It's beyond me how that would come out of a lawyer's mouth. And then he was on Surviving the Survivor, that interview.
Yeah, I saw that.
About, Dan Markel would agree with me. And my God, representing one of the murderers and quoting the victim is so, it's so beyond the pale. And so there are examples like that where his feel, and that's important, and the law is important, clearly, but you have to relate and understand how jurors are going to respond. And I don't think he's very good at that at all.
Yeah. Well, what did you think about the defense theory that Charlie was the victim of extortion?
I thought, like everybody else did, it was an absolutely silly defense. It was good in the sense that it accounted for every piece of damning information that had to be accounted for. I mean, why was the money that they got stapled? And, why were you paying Meg Banowa for a job she didn't do? And, all of that. But it was silly. I mean, the idea that two people from Miami who had never been to Tallahassee in their lives, who are doing drugs and drinking the whole time, who can't, on the return the second time, they lose the rental car, and one of them has to go walking around trying to find the rental car. The other one on the trip shoots, fires the gun
through the gas line.
The idea that these two nitwits could have put together this sort of intricate crime is unbelievable. I mean, you could make a great comedy movie if you didn't have a murder coming out of it. I guess I wouldn't do the murder and I'd have the miss on that, but it would make a great comedy movie.
Speaking of that, did you ever see the comedic skit that Mentor Lawyer and I did, making fun of the defense theory?
I did. I've seen a lot of yours, and I've seen that. I think you do a great job with those skits, and where you find Donna's clothes or Wendy's clothes is beyond me. But you have another career in front of you. Mentor Lawyer is not as good as you. The skit was very funny, but you have another career out there.
Oh, thank you. Thank you for your kind words, because I also got lots of people hating on me and being very offended by it.
Never satisfy everybody. Never. And so I think you do what you think is right, or what you want for you, for what you can do with the program. A lot of people like it, and if people don't like it, they don't have to watch.
Yeah,
they can go watch something else. God.
Yeah, thanks. Well, why don't we show your masterful letter?
The protocol is, I don't know where you would find out what the protocol is. And then you said you had written a letter. And I said, well, you're another lawyer, and if you think this is okay, I'm going to do it. That was one thing. I mean, I wanted to do it, and those were the reasons. The other was, I was so ticked off, in part by the claim that they made as to why they needed to be in a small courtroom, which was clearly made up. They just didn't want to have more people who might support the prosecution in the larger courtroom. And the other part of it was the public right of access to courts, the First Amendment, the Sixth Amendment right. And that troubles me because it's a constitutional right to be there, but there's nobody in a criminal trial that asserts the right of the public. The defense is going to make whatever claim they think is to their interests. The state on occasion will talk about the rights of the public, but typically doesn't, because the state, their interest is not introducing issues that are going to be raised on appeal. And so they're not likely to do it. In big cases, if it's the New York Times or the Washington Post, the media may come in with their own lawyer and intervene, which means they're not a party to either side, but they're allowed to come in and speak, and they'll make a case for the media. And, by the way, mention the public right. But nobody really represents us. And we have that right. So I thought, I really want to be able to make the case for the public. And I saw a little thing come up about it also protects the defendant. And that's true. If you permit somebody who thinks in their individual case, they're better off not on the showing that they made, which was no showing at all, then you set a precedent for doing it in other cases. That the Sixth Amendment public right is there to protect the defendant. So you can't have private trials and you can't have star chamber affairs. The First Amendment right says, and the public has its own independent right to be there. And I thought nobody's going to make this case. At least I don't see that anybody's going to do it. I'm going to sit here and write, something. And that's what I did.
And why do you think it wound up in the court file?
I have no idea. I heard today, because I watched the hearing this morning, that Judge Everett took all the letters that were written and provided them to both the prosecution and the defense. So they got those letters, because I don't know why mine got in there. I guess, I didn't get a chance to see your letter. I looked for it and I didn't see it posted anywhere, and you may have, but I'm not good at finding things.
I did, but I took down the post because I was kind of afraid that crazy people would start bombarding the judge because I had the judge's
Oh.
Well, it's public, but still, I kind of felt a little bad. Like maybe I shouldn't put that out there.
Yeah. Well, I couldn't find it, and so the only guess I have is that because I made some sort of quasi-legal arguments. There hardly a brief or anything like that. That's why it was put in. I just have no idea.
Because you actually had legal citations in it.
I did. Well, I did. Although I must say, if you were writing even a small brief, you'd have many more legal citations, and I was a little antsy about it. But I thought, I'm writing a letter. If I do more, I'm going to feel even more uncomfortable about sending a letter when I'm not a party and I'm not an intervener. So,
Well, have you ever felt so compelled to write a letter to a judge like this before?
Well, I've never done it before, so I guess the answer would have to be no.
Wow. Shows how much you care about this case.
Well, and also the First Amendment and the Sixth Amendment rights. I really do believe, if we have those rights, somebody's got to be out there protecting them. And that's not to say that the judge wouldn't do it, but there's not an adversary presentation. Now, I think, what mattered more is the arguments that I assume you made and the argument that Katie Coolidge made, which is the logistics of not doing it. And that was the practical argument that I think had to carry the day. But nonetheless, I thought somebody should stand up for our rights as citizens to be able to participate in the process and oversee what's going on. It's important.
Yes, and this is Florida, where they have the sunshine laws.
Exactly. Which is why, by the way, I'm thinking of Rashbaum again. He got me so annoyed. It's easy to get an Italian annoyed. But he got me so annoyed in that interview with SLS when he was saying
STS.
he was STS. What did I say? SL, yeah, STS.
SO.
That's right. When he talked about how troubled he was that so many jurors said that they knew about the case and they had an opinion about the case. And I thought, my God. We always used to have that joke, the jurors you're going to get are the ones who don't know enough to know anything, and they're the only ones you're going to put on a jury. Of course, people may know about this case if they read a newspaper, but he didn't distinguish between newspapers and, some of the maybe admittedly some of the content providers or content creators on YouTube who have a position one way or the other. He also, it seemed to me the process worked fine because those potential jurors said told them, yeah, I've read something. Yes, I know something. And many of them said, I don't know that I can, be fair. That seems to me to be exactly the way this process is supposed to work. It shouldn't be an indictment of the process.
That's right. Well, were you thinking of going to Tallahassee for Donna's trial?
I wish I could, but I can't. I can't.
Okay.
I'm going to be leaving for Italy a couple of days after, and so it just doesn't work. They didn't schedule the trial to fit my calendar very well.
Yeah, well, going to Italy sounds like a lot more fun than Tallahassee to
I
watch
don't
your
know.
trial.
I don't know. It seemed to me to meet some of you who are so interesting, and your programs would have been a lot of fun. But
So how did you discover YouTube and all of this coverage of
same way
Markel
during
case?
COVID, I didn't start with trials on YouTube. The first thing I discovered was the spy museum in Washington that has these ex-CIA agents talk about their cases. They were doing these lectures. And then I found, Richard III and his body that they found in the parking lot in England. And I discovered on YouTube, you can find anything. And I was so amazed. And then I went into the trials immediately thereafter.
Yeah, it seems like you've watched pretty much every video about the case.
Well, I'm an inveterate TV watcher. I'm not even ashamed to say it anymore.
Yeah.
And I'm a multitasker, so I can have that on and be doing something else at the same time. And it's been very, very interesting. I wish that I were teaching criminal procedure right now, because some of what's happened at these trials is such a good teaching example. Amazing teaching examples for students, and what they read is helpful, but what they can see in action for themselves, is so much more important. So in fact, I have a friend who's doing trial ed right now at Nebraska, and I just sent her a couple of information about a couple of clips that I thought she might want to use.
Oh, that's great. So do some of your friends or colleagues also follow this case?
No, they're like your friends. I talk about it all the time. And
But nobody
listen,
cares.
but they won't, but they don't look. Yeah, I don't know if you're frustrated by it. I am frustrated by it, because I'd like to have somebody that I could talk to about it. You at least, I shouldn't say at least, but you go on the air and talk to everyone about it. I am thwarted. I don't even do that. But no, they're not.
Well, here's your chance. So what do you think about Wendy's culpability in this? Would
I
you like
think
to
she's
answer?
guilty. Yeah, no, I think she's guilty. I don't think it's as easy as I guess John Steinbeck makes it sound. He may be
Carl?
right. He's done Carl. What did I say?
Carl.
Yeah, not his brother, Carl. He may be right. He's certainly done more trials than I have. And I think there is no question whatsoever that her going to the crime scene the day of the murder shows knowledge. I don't think there's any credible way that anybody wouldn't believe that shows knowledge. But knowledge isn't enough. You've got to show an agreement for conspiracy and for murder in Florida, even more than that, to be culpable for those crimes. I think there's enough. You've got the knowledge about when Dan was leaving town, the 2 times that Jeff left town, the fact that the cars that were rented each time looked like Jeff's car. I mean, all those things had to come from Wendy, and I think that's more than enough. But it's not as easy as the case against Charlie, and even the case against Donna. And then the immunity issue, if and when, and I hope they do, when they decide to prosecute her, the immunity issue is going to mean that probably going to be a long pretrial, Castigar hearing on what can be used and what can't be used, and all of that. And so I think it's going to be, more work. It's not going to be as easy for Georgia and for Sarah as the other couple of trials, because there's going to be a whole new element that they're going to have to address. But I think it's, it's certainly possible to do it. And I think they should give it, they should prosecute, they should charge her and prosecute it. I think they'll get a conviction, but I don't think they're ever going to have more than they'll have after this trial is over. So they might as well give it a shot.
But to be optimistic, remember what Patty's Playhouse said? She said that she happened to run into Jack Campbell maybe a couple of months ago at an event. And she said, I know you're rushing to get back to work so you can go get Wendy Adelson, right? And he kind of laughed and he said one at a time. But supposedly he also said that there's more evidence out there, which of course we don't know.
Right. And I'm not surprised. I wouldn't be surprised to know that's true, because with the immunity issue, the more that they do in a trial while she's covered by immunity, the more potential obstacles when they do prosecute her. Now, if it's independent evidence, it won't matter, because the immunity issue isn't going to cover evidence they found a different way. But if any of it relates to something they'll question her about on the stand, it just adds to whatever they're going to have to argue later. And if they don't need it in one of these prosecutions, I don't see any reason why they would go ahead, and do it now. I was wondering when I saw the motion that it's taken them too long to prosecute Donna. And I listened to that this morning. I thought about an argument that I wished that Georgia had made this morning. But that aside, I wondered if that motion may just decide them, once Donna's trial is over, to just go ahead and charge her immediately. And I hope that's true, because they're going to have the pretrial stuff, which will delay it, I think.
Okay. Well, does Wendy's use immunity automatically carry over to each case, or does the state re-offer it each time?
Well, whether it's reoffered, whether technically they offer it each time, or they gave it once and said, you have it, she's got to have it, because in Florida, at least as I understand it, if you subpoena somebody to testify, the immunity comes with it. My guess is it's reoffered each time, because it's hard for me to believe that if I prosecute A and give you immunity, that I say to you, hey, and if we decide to prosecute B, you still have the immunity. It just seems like the cleaner way is, once the next prosecution starts, they subpoena her again and the immunity is triggered again.
Okay, thank you. Yes. Well, what about, I mean, this is kind of a dumb question, but people keep pointing out that Wendy has said multiple different things about whether she drove up to the crime scene at different trials, as well as the police interview. So could they still use that information to cross-examine her if she had a trial?
Yeah, I looked at that a couple of weeks ago, because I've heard a lot of the lawyers, a couple of them from Florida, say, well, they'll be able to impeach, that is cross-examine, because they're different statements. The cases on the constitutional, the immunity, seem to say that you can't impeach because it's a derivative use, unless you first show that the person who gave the testimony breached the agreement by lying. And so if I'm right, they're going to have to show that she breached the agreement by lying, and then we'll be able to use it to impeach. And to do that, it's not simply that somebody lied. It has to be on a material fact. It has to be something important to the trial, to the conviction. So it's not as if, you're not going to be able to breach an immunity agreement if I say one time I wore a red blouse, and the next time I say I wore a blue blouse. That's not material to anything. And you're not going to be able to impeach to the extent I say, I think, maybe, I'm not sure, because those are not strong enough affirmative statements. So it's not, but I don't, immunity in terms of then prosecuting on derivative use, in the context this came up, and the person testifying over and over again has not, to my knowledge, happened very much. I mean, it has happened that somebody has breached the agreement. So supposing Luis Rivera said, hey, I'm not going to testify anymore. So he's breaching the agreement. Then you can go, and that's a clear case, and that's the way you typically see it. Or many years ago, there was a case of two cousins who murdered women in California. And then one of them went up to, I think, Oregon and murdered more women. And to avoid the death penalty, he agreed to testify against his cousin. And that was the deal. Now, it's not an immunity deal, but it's analogous. That was the deal. And then they didn't think that he really was as forthcoming as he should have been. So you have to look at, I hope I'm not being too, in the weeds, but you have to look at what the person actually testified to, and then prove that that person breached the agreement. And, then you're off and running. And you can use, and you've heard the lawyer say, this, Judy, you can use anything that doesn't come from her testimony. So that first interview is completely, admissible. Jeff's statements are admissible against her. She's a co-conspirator. So what happens with co-conspirators is the statement of any co-conspirator is the statement of all of them. So those will all come in. My strong guess is they're going to be able to use those earlier statements by her. That the prosecution is going to have enough to be able to show that they're entitled to use it all. But I think what they're doing now is being careful, because they don't want to. I mean, the Fifth Amendment privilege against incriminating yourself is a really important protection, in our criminal justice system. So courts are careful about looking as to whether you're breaching that right. So I applaud them for being careful right now, as much as I'd like to hear some of this other evidence.
Yeah.
I think the fact that I want to hear it isn't as important as them protecting it so they can go forward with the best possible case against her. And
That's
boy,
right.
I hope they go after her, because I really, as I said, the idea that you would, for your little boys, try to wipe out their father's presence completely is so evil to me. I just can't get my brain just doesn't want to go there. It's just so evil.
Right. Everyone talks about what a great father he was. He had nothing but love and praise for his kids. Yeah. Rosemary wants to just point out that Wendy also knew Dan's schedule. Yeah, I think didn't that text say that she was asking him if he was going to be in town specifically July 14th, I think, through the 18th. And then she said something like, I want to take the kiddos to someplace on 16th
I think that's
or something.
Right.
Yeah.
So I mean, that's a lot of coincidences that the first attempt happened in a car that looked like Jeff's at a time that Jeff was out of town. And I don't know the first time whether there's any evidence that she knew or made a point of finding out that Dan was going to be in town. Maybe that's some of the evidence they've got that they'll use. Then the second time, it's still a car that looks sort of like Dan's. Jeff's. And she knows that Dan is leaving town. And again, she knows that Jeff is leaving town. I mean, it's not impossible in this world, but boy, that's a lot of coincidences. One on the other.
Yeah. And then the whole ridiculous broken TV alibi. I mean, it just sounded so ridiculous. And she was totally in the middle of that.
Yep.
Yeah. So, okay. So Yalba has a good question. If I get subpoenaed to testify as a fact witness and I confess to a crime on the stand unrelated, they can't use that against me?
Yala, that's a great question. And that's called trying to get an immunity back. The risk of abuse and derivative use immunity is that the individual will then get up to testify and get a bath for things that were not contemplated. So the way that prosecutors avoid that, and if you well, the way that prosecutors avoid that is they don't ask open-ended questions. They don't say, so what have you done for the last 6 months? And then you, Yala, say, hey, I committed 3 murders last week. They ask specific questions. And the law is that if you, as the responder, if I ask you a specific question, did you see Dan yesterday? And your answer is, yes, I saw him yesterday. And last week I murdered his mother. That would be considered non-responsive, obviously, to the question that was asked and not protected by the grant of immunity, because you were trying to take that grant of immunity, which protects you, and make it a sword to, give you greater protection than you're entitled to. So there's law on this. And as I say, what you're trying to do is immunity bath, and the law is out there to prevent you from getting there, assuming that the prosecutors don't open up the opportunity for you to say more and be responsive. So they have to be careful how they ask and what they ask.
That's very enlightening. Thank you. Okay, this is a good question. Can Charlie decline to testify for the state? Because I know some people got excited because it said there's an order to transport Charlie as for the state. So what could that be about?
Yeah, he can't, well, yes, because the case is still on appeal. So he's still covered by his privilege not to incriminate himself. Even if that weren't the case, say all his appeals were gone, there's not much you can do to him. I mean, if I call a witness to the stand and the witness refuses to answer questions, the judge will hold the witness in contempt. The witness is going to end up in jail until the witness testifies. But he's already in prison, so there isn't much of a push that the state can use to get him to talk. If they know he's going to assert his Fifth Amendment privilege, then they can't put him on the stand at all. You don't put somebody on the stand in a criminal trial, ask a question, he says, I'm not going to answer the question because it might tend to incriminate me. So I don't know, Janet, why he's on the witness list for the state. I mean, we'd like to believe that he's decided to make a deal. It's hard to believe that that would be true and that hasn't leaked out somewhere, somehow by now. Maybe they've got him there, in an overabundance of caution. They think maybe they can use him in rebuttal. But even so, if he says, I'm not going to say anything because my case is on appeal, they can't make him talk. And I don't know what they'd give him immunity for now. I mean, he's already been convicted of the murder.
Yeah, it's a big question. So similarly, Harvey can agree or just assert his Fifth Amendment privilege too. Like he doesn't have to get up there and testify, right?
Yeah, they'll have to do something with the judge. Well, they'll have to make some sort of proffer that he is subject to incriminating himself. I mean, you just can't willy-nilly decide, hey, I'm going to claim a Fifth Amendment privilege. You've got to have a realistic basis for making the claim. If he's got that, yeah, they can't unless they want to subpoena him like Wendy, and then he'd have immunity for anything he says. But I don't know. I mean, at least for Donna's case, it seems to me they've got enough that doesn't seem to be that there'd be anything substantial that he would add that would lead them to do that. But you're right. He can assert, if he's got a basis for it, and it seems as though he would, he can assert the privilege and they'd have to respect it.
Yeah. Okay. I don't know if you can answer this. Why do you think Wendy isn't fully transparent with her immunity during testimony? It was because she denied telling Jeff about the hitman that opened the door to hearsay, right?
I'm not sure I understand the first part of that question.
Yeah.
The second part was part of the motions today. If you remember from that trial, they wanted to get in that information from Jeff, and Rashbaum had a hissy fit about it.
Yeah.
Because he said, gee, we had a deal ahead of time and the prosecutor's being unethical here. And they had to call Wendy back to say she hadn't made the statement. And then they could call Jeff in to impeach, to say, yes, she did. She said it to me. That's that last part. Why she isn't fully transparent with her immunity. I don't know. I'm sorry. Maybe Judy, you understand, you do it. I mean,
Yeah.
I'm just.
Well, I think we would just have to speculate that we think she just likes to lie. I mean, that's what I
true. That's
personally
not
think.
speculation.
She likes to lie. That's what Jeff Lacasse said, is that she just lies with ease. And it's like she enjoys it.
Yeah, I don't understand it. I mean, I don't understand why. But you're right. She lies about things that don't matter. That's another thing, actually. I'm thinking of other things that annoy me about her. She'll be caught in a straight out lie. And then by Georgia. And Georgia will say, but think of one. It was when she claimed she didn't know gibbers, how you spell gibbers. And Georgia said, well, here it is. It's in your phone record. And she said, yes, as though she had told as though it wasn't a lie. And
that's right.
I'm telling you, I just can't stand it. I would, I'm not a violent person, but I think, I would pound a pillow against the wall for sure.
Well, I think you sort of touched on this. How do they decide when a person has been subpoenaed, who gets immunity and who doesn't?
That's up to the state. The state has to put its case together and decide how it's going to make a case that it feels it has a reasonable basis to prove to a jury and get a conviction beyond a reasonable doubt. So it's the state that makes that judgment call. Generally, they do not give a deal in a case in which there's more than one person involved in the murder. Generally, they do not give a deal to the person who actually was the one who did the shooting. In this case, it would be Secreto. That's generally not the deal they make, although, I know of cases where they've done that. But it's up to Georgia. It's up to Jack Campbell to decide, can we make this case without it? Or, if we wait 6 months, are we going to be able to make this case without it? Or should we go now? In fact, I think, that question triggers why they were so slow at the beginning, because I think they thought that Katie would offer to give information on a deal early on, and that's why they didn't go after Charlie immediately or Donna, because they thought that they'd get Katie to turn and then they'd have her, and she, for reasons maybe her lawyers this time, because they're on that witness list, will explain, didn't do it.
Would you like to take a guess as to why Wendy went to the crime scene?
Yeah, I don't think she could help herself. I think in some ways she's not a planner. She's impulsive and she's a worrier. And remember, they had one try before that went south. And I think she spent part of that morning fidgeting about, did it happen, did it not happen? And she thought, I'll just go and see. And she didn't expect, I'm sure she didn't expect that the police would be already there, that there would be the barricade up for already. And now she had to come up with an explanation for it. And she started out giving a relatively true explanation in that first interview. And then that explanation, as soon as she gave it or close thereafter, became clear to her that that wasn't a good explanation to have. So she's been trying to backtrack and only digging a greater hole. But I think she just couldn't help herself.
Just like what Charlie kept repeating.
And he knows her better than I do.
Yeah, she couldn't help herself. Yeah. Do you think Charlie could be offered something to make his time in prison more comfortable if he testified against Donna?
Well, first, I don't think he'll testify against his mother.
Agreed.
But I guess, I don't know, whether the state can make a deal to have him spend time in federal prison. They'd have to pay for it, and the feds would have to agree to it, which might make it a little better. I think it's more likely that he would make a deal and testify against Wendy to make Donna's time easier, or that Donna would be willing to make a deal and implicate Wendy to make Charlie's time better. And in that case, maybe they would be willing to reduce Charlie's sentence some if they got Donna to say Wendy was involved. I've heard a lot of people say she's not going to, say anything against her daughter. But I mean, her daughter wasn't even, her daughter seems to me to have just tried to cut them all the same way she did with Dan.
Yeah.
Wipe them out of her life. She seems to be very good at doing that. And so I don't see. Now, I'm not a mother, so maybe mothers have a very different feel for this, and I will defer. But I don't see as if I were a mother, why I would say I'm going to continue to be loyal to you, and my son is suffering because of it, rather than make a deal and get my son some relief.
Okay, I didn't realize that was possible to make a deal that also involves somebody else.
I don't know. I'm talking, I don't know that I've ever seen it happen, but I don't see why it would necessarily be, out of the realm. If the state can make a deal to reduce your sentence for whatever reason, seems to me it should be able to make a deal to reduce your sentence because somebody else is going to help, and that's the condition. You've seen it, the way I have seen it, but I'm not sure there have been convictions, is where a parent will make a deal and plead in order to avoid a prosecution of a child, or in spouse situations, a little different because you're avoiding the prosecution, but it seems to me it's the same principle. But if somebody knows better, I'd be willing to be better informed, because I like to, this is the law professor in me, this is the way it should work, and this is the way I would argue it. But if somebody can tell me, not true, I'm more than happy to be informed.
Sure, maybe I'll ask Dave Ehrenberg on Monday.
Okay.
Yeah. Oh, did you watch the hearing today?
I did.
Okay. Were you surprised by anything?
Not about the rulings. I was a little surprised, but that's because I don't know Judge Everett, how well informed and how good his questions were. The one place, and I said this, or I alluded to it earlier, that I wish Georgia had done a little differently, was the argument about not letting the information regarding the phone records and or the Sun Pass in, because they were prejudiced by delay. And I'm not sure that's true, because if you look at the times, the murder is what, 2014. Dan admits, what did he say, 2016 was, on the, and then when he heard why Everett asked the question, he tried to backtrack, but he said 2016. Dan said those records were only available for 3.5 or 4 years. So that would take you from 2014 to 2018. If you remember, Judge Everett said, well, didn't the Supreme Court of the United States say prosecutors are not ethically able to just bring prosecutions because they want to? They have to have a reasonable basis to believe that they can get a conviction beyond a reasonable doubt. And I don't think that in 2018, you can quarrel and say necessarily that's the evidence they had. Dan kept saying probable cause. It's not probable cause. Probable cause allows you to make an arrest. You can't convict on probable cause. So I wish they had made that argument, because I don't, and if the records weren't available after 2018, then where is the prejudice with regard to those records if you prosecute in 2024? You wouldn't have had them in 2018 either. And unless you can prove that that's the point at which the state had enough information ethically to go forward, and then you get to, were they acting, unethically by waiting, I don't even see where there's prejudice. But anyway, I'm sorry, Griffin, that wasn't quite an answer to your question. I didn't think anything was a surprise today. He reserved on a couple of things. And I think that's prudent because he can look at more law. And the more that he does that, and assuming that he then rules for the state, the more insulated the case is from any kind of an appeal.
Yeah. Well, I wasn't totally surprised, but I was just kind of wondering, why do you think the judge denied the defense motion to use the questionnaire? Because wouldn't it be more efficient to use a questionnaire?
Yeah, I don't know. In New Jersey, at least the trials that, I seen, they were always using a questionnaire to get some of the questions out of the way. And recently I was called for jury duty, and we were on a cattle call, about 300 of us. And they went through some questions and said, just, stay on and tell us if you answer any of these. So they got through the preliminary kinds of things like, what, let's see, let's say there was an exception that said, if you're a lawyer, it's an automatic. There is no such. But if that were that, you can get rid of all the ones that are going to be automatic exclusions. I'm guessing that the questions they wanted to ask, listening to Sarah, were questions that went more to, are you going to be biased in some way? And what she said was, we're going to end up doing this anyway. It won't be efficient because we're going to find answers here. We're going to have to pursue it with them. And we really want to see, what the jurors look like. I also think that Judge Everett just doesn't like the questionnaire. And, judges have, sort of things they like and things they don't like, just like the rest of us. And, and he just didn't want to use it. But
Okay. Yeah. And I was just a tiny bit surprised that the judge said using the Dulce Vita transcript is okay if the witness, which would be Katie, if she's explaining it, and if she can authenticate and lay a foundation for that. So, I mean, that made sense, but I didn't realize that could be a reason to
yeah,
let
well,
the transcript in.
what's going on is the question is the transcript accurate, or is it just the state's listener who wrote it in a particular way? And if you and I listened, we might hear something else. So what she's going to authenticate is the transcript reflects the conversation that she was a part of. She was there, and she's going to say, this transcription is an accurate rendition of what the conversation was. That takes out of the equation the claim that, the transcriber just didn't hear it right or was listening to it and hearing things that helped the state. Now it's out.
Yeah, and isn't it strange that the prosecution didn't ask Katie more about that during Charlie's trial? So I sort of wonder, were they afraid Katie would just say stupid things or, didn't remember anything about it? I don't know.
Yeah. But in Charlie's trial, if I remember, the transcription was used, wasn't it used for demonstrative, or no, maybe they didn't even use it for demonstrative purposes.
Yeah.
I don't remember now.
Remember.
There's too many trials.
Yeah.
That's, and that worries me about doing it, not having done as many trials as clearly Georgia and Sarah had done. But having taught classes, there are a couple occasions when I taught the same class twice because we needed coverage. And it's tough to remember what you said to class A that you need to be sure to cover with class B, because they're active sessions, and you may have a script, but then you get taken off the script by what somebody answers or what a student asks in class. And I have a little bit of a concern that they're going to be able to keep straight in a trial. Now, there are two of them that'll help, that they actually asked the question this time and not that they asked it the last 2 or 3 times. So, of course, they did it this time, too. I know that sounds silly, but it's harder, at least for me, it's harder than you might think to do it.
Yeah, actually, come to think of it, I think they didn't allow the transcript of Dolce Vita last time.
Right,
But
right.
now this time, possibly. So
Well, now they
that's good.
can because she can authenticate it, and they didn't know she could do that. I mean, I suppose they could have tried last time. Maybe they didn't think about it, you know. It's hard to think about everything, and they did a terrific job about thinking about virtually everything that needed to be thought about. I mean,
Yes.
I'm
Yes.
almost in awe of it, actually.
Yeah. Okay, big question. Tell us your opinion. How much involvement do you think Harvey had?
I don't know. He's really a stealth player in here. He let Donna run the show. At least that's how it appears on paper. Um, but there are, there's some little thing, when he got angry and he threatened people because he thought that they were, offending his children, and the monkeying with Charlie's dental degree that he was involved in. So I think he is involved, but I think it's going to be hard because all the paper stuff and the wiretaps. It's Donna all the time. It's Donna all the time, and he manages not to be front and present, even though he may well be. And he's what, 80 now? So by the
80.
time they do this case, and if they do prosecute Wendy, I think they'd have to do them together. I mean, I don't know how long you can wait to. I mean, I don't want to be an ageist about this, but there's a point at which, I don't know that it seems to me it may not be worth the effort to try to do it. But who knows? There may be evidence. Who knows what Donna's going to say? I think she's a little bit of a loose cannon. I think if they let her get talking, she may say something that really helps.
Yeah, yeah, that's right. Did you notice that mad look on her face when that flight as consciousness of guilt issue was decided? Yeah, she gave this sassy, indignant, sort of grimace face. And I was
Well,
like, good, let the jury see that.
exactly. And if she'd only not written anything in her diary or whatever she called the thing, and she'd never said anything, I mean, she wants to be indignant. She should turn the mirror and look at herself.
That's why it was kind of funny that in the motion about the courtroom, her attorney was concerned that the jury couldn't see her. But I think that's actually kind of a bad thing because she does sometimes in court, start, making these faces and stuff, and you can just see her like reaching the boiling point where she's ready to just bust out with
I
something.
agree with you. I agree with you.
Yeah.
Did you think it was noteworthy that Harvey wasn't even on a Zoom call to watch that hearing?
I wonder if maybe psychologically he couldn't handle it. Like he didn't even want to be on it because the Markels were there on Zoom. So they would see him too. So I mean, I think Harvey at least has some sense of shame, based on how he reacted after Dan's murder.
Mm.
Yeah, so he probably didn't want to show his face on that Zoom.
He could have turned the screen off.
Yeah, that's true. Yeah, maybe if they allow you to not show your face. Yeah. So I have no idea how he's doing, but supposedly Wendy has moved to Texas and, she's probably trying to move on with her life, living her best life after just abandoning her mom and things. Yeah. Okay. Thank you guys for giving this info. Yeah, people are saying that the transcript was used.
Okay.
Yeah, but the jury only got the recording. Yeah. Well, my voice is dying as usual.
Okay.
Like I said, I feel like I'm getting sick again, so I'm so sorry. But let's see. Let's see. What's this? Your letter was superb. How does that work? Who decided it came into evidence? Yeah, I think, didn't you say you have no idea how?
I have no idea, and I will say again, I was really, being an officer of the court, not in Florida, but nonetheless, I was really reluctant because I didn't know what the rules were, and I didn't know where to research to find out what the rules are. I mean, usually the people who can actually put something into the record are the adversaries, or if you're what's known as an amicus, you've got an independent reason to be there. But to be somebody in the public and write, I mean, I just didn't know. I know how it got into the record from the way the documents went. The judge this morning said he gave all the letters to the state and to the defense. The state put that letter on the docket. That's how I know it got there. You know, whether it had to be there because there was law in it, I don't know any of that. I just know that so I can tell you the, you know, the sort of the trail, but I can't explain the trail.
Oh, okay. Do you think the state would consider indicting Wendy on a lesser charge, not first degree?
I don't know. I mean, if she did if the evidence is believed, it's first degree murder and conspiracy. So I don't know why they'd charge something else. And they can always charge, I believe Florida does this, they could always charge first and second degree and conspiracy, and then the jury could, you know, make up its mind what it is. But I don't see anything in the evidence. Of course, I don't know everything, and I don't know what the state has that we haven't seen yet, but I don't see anything in the evidence that would suggest it's not first degree, but it's something else that makes her culpable. Seems to me she either knew and agreed and did things to help, or she didn't. Now, I do know, having said that, I don't want to babble, and here I am babbling. I looked at a Florida murder case, well, months ago now, so I'm not going to remember it well. That, as I recall, suggested that to get somebody for first degree murder, there has to be in a substantial conduct. And I think it's the Williams, the Florida case where the mother of the victim they claimed was eaten by alligators or something.
Oh yeah, Mike Williams.
That's right. I think it's that case, that Supreme Court case, that talked about to get somebody for first degree murder, there's got to be some
overt act.
Yeah, something more. Can't just be a little bit. But I'd have to go back and read the case because you're carrying me from memory on what it said. And that would be a reason then Top Cat 88 to do not first degree, but maybe something else. But certainly conspiracy.
Well, I think she did do an overt act, which was to find out Dan's whereabouts.
Right.
And participate in the whole fake broken TV thing.
Right.
And maybe framing Jeffrey.
Right. And the Williams case, what the wife did was encourage him to go hunting with the
fake
that day. And I'm not sure, maybe that there's more here, and that would make it first degree. You're right.
Yeah. Okay. Last question, I guess. Do you think the defense will win their motion next week to keep out Corbin's testimony? As I don't think they wanted to keep out his whole entire testimony. I think they just wanted to keep out this, what is it, a summary, like a slide presentation.
I think they're gonna win that he's not an expert, that he didn't qualify as an expert. But the demonstrative, his was demonstrative evidence. And if I'm the prosecutor and I can put up on the screen for everybody to see, you know, all the people involved and all the arrows showing how they're involved, and I can put up things like that to help the jury visualize. Now you move it over to the wiretap. I can't do the wiretap things because I don't have the training to be able to do it. So I don't see that it's so much of a stretch, at least that's the argument that I think I would be making, that he's not an expert, but he's providing the demonstrative exhibits as my proxy, because as the lawyer, I don't know how to do it. I mean, I can't they can't explain it the way he can. And if he can explain it without, as a fact expert, here's where the towers were, and here's where the people, drove, and what else? Those things. I don't see why they can't use pictures to help. But we'll see next week, I guess. I had the sense, though, today at the end of the hearing, and if those of you listening to the hearing, you may have gotten a different sense. But I had the sense that the prosecutor, the Georgia and the defense may be working this out as to what it is those slides will be able to say and show. Because if you remember at the end, Judge Everett said something along the lines of, he knows how these deals, it seems to be that they're going to work it all
Everyone
out.
seems okay.
Yeah.
Yeah. Okay. Yeah. Well, it's interesting that the defense did not include that questionable summary. For some reason, they don't want it to be made public, probably because it makes Donna look really bad. That's my guess. Why didn't they include it? Yeah. Can you answer one more question?
Sure.
You okay? Okay. Can the prosecutor force a yes or no answer from a witness? I ask because Wendy is vague and dances around with her answers.
Sure. You're entitled to a responsive answer. You're not obliged to, you're not even obliged to listen to let me tell you a long story, rather than get a yes or no. If the question can be answered yes or no, the prosecutor can force a yes or no answer. Now, it may be that the witness will say it can't be answered yes or no, and that may be accurate or not accurate. But if it can be answered yes or no, yes, you can force the witness to tell you.
Yeah, but I think Wendy also kept acting like she couldn't remember stuff. Just saying, well, I think, or, when asked about her book and stuff, she just acted like she couldn't remember. So that kind of got her out of having to say yes or no.
True.
Yeah.
That's true. Can't answer yes or no if she says she doesn't remember clearly. Although she's somebody who never even read the indictment.
It's like you're an attorney, you're legally trained, and it involves your brother, but you didn't read anything.
And she doesn't know what use immunity, means,
or contempt.
When she's the one who's been given it, and she's the one who's using it as, as a protection, and she doesn't know what it means. She is so, well, I don't like her.
Yeah. Oh, no, I don't think that's what they said. I think they were talking about summaries that Mary Hole had prepared. So she can't just give more concrete info about Donna's finances or her bank balances, but she can still be there to testify.
Yeah, and I don't remember exactly how they came out. They said they couldn't use the summaries. He said you couldn't just use information that the Adelsons are rich, but to the extent it relates to, they have the money to do all this stuff, that's all relevant. And I guess I don't remember whether the answer was she can do all of that in the context of the specific. I'm sorry, I just don't remember.
That they had enough funds to, make this offer, pay for the murder,
That's
things like that.
Rent a condo, all of that,
Yeah. Okay. Well, unfortunately, I do have to get going soon. So do you have any closing remarks for all these people who are so engrossed in Dan Markel's case?
No, except I'll say again, I share your interest, and Judy, I think you do a terrific job with your show and your ability. I love that you do those readings. I mean, I never thought that actually hearing somebody read some of the documents would be so helpful, and I do think it's helpful. And I think the little skits you do just adds so much, context and fun. And then a murder is a murder, and it shouldn't be fun, but it's still just really great. So I'm just honored that you asked me to be a guest. So thank you.
Thank you. It's nice to meet you because of this case. So as I've mentioned, people said Dan was the great connector he was like Kevin Bacon of the legal profession. So it's really cool. Yeah. So everybody wants you to come back. So hopefully you'll have time.
Anytime you're willing to put up with me, I'd love to be here. Thank you.
This was like really great, useful information from someone who's a scholar. So really appreciate that.
Thank you.
Okay. Well, we'll definitely be in touch then. Thank you.
Thank you.
Take care, everybody. Have a good night.
Bye.
Bye.